Hello everyone, this is Urvashi Chauhan and you are watching Courts Today by Live Law. We bring to you the latest and in-depth legal coverage. Coming to you with a brief of what all happened in the Indian courts today. Starting with the 50th anniversary of the landmark judgment of Keshwananda Bharati versus State of Kerala. The landmark judgment was pronounced on 24th April 1973, where the Supreme Court outlined the basic structure doctrine of the Indian Constitution. The case is also known as the Fundamental Rights case and the Basic Structure case. To date, it is the largest ever constitution bench of the Supreme Court of India with 13 judges. The judgment asserted that while the Parliament had wide powers, it did not have the power to destroy the fundamental features of the Constitution. To commemorate the 50th anniversary, the Supreme Court has formed a web page dedicated to the judgment. The formation of the page was announced today by Chief Justice of India, D.Y. Chandrachud, who stated that the said web page could now help researchers across the world to learn more about the landmark judgment. The web page provides you with comprehensive details like the background of the case, key legal issues raised, arguments made, conclusion reached, and the reference material used in the case. You can access the web page link in the description box below. In a significant development, the Supreme Court today set aside the order of Telangana High Court, which had granted Lok Sabha member Y.S. Avinash Reddy interim protection from arrest and directed the CBI to conduct the investigation in a given manner in the murder case of former Andhra Pradesh Minister Y.S. Vivekanand Reddy. Earlier this month, CBI had issued summons to Avinash Reddy. In anticipation of his arrest, he approached the High Court. The High Court reserved its order till April 25th and granted him protection from arrest till then. A petition before the Supreme Court was filed by N. Sunitha Reddy, the daughter of the murdered former minister, challenging the decision of the High Court to grant Avinash Reddy interim protection from arrest. She had also challenged the High Court directions to CBI on how to question the accused, which included various directions like the questionnaire to be made available to the petitioner. Today, the bench comprising CJI D.Y. Chandrachud and Justice P.S. Narasimha stayed the order and also remarked that the findings of the High Court were clearly premature. The court further said that an order of this nature would harm the investigation. An order that a person investigated should have questions in written or printed form allows grave prejudice to investigation. The Supreme Court today said it will hear the petitions challenging the constitutional validity of the Muslim Women Protection of Rights on Marriage Act 2019 in November this year. To give you some context here, you already know that in 2017, the Apex Court in Shaira Bano versus Union of India had declared the triple talaq or any other form of talaq having the effect of instantaneous and irrevocable divorce pronounced by a Muslim husband as unconstitutional. Post this, the Women Protection of Rights on Marriage Act 2019 was passed, criminalizing pronouncement of divorce in such a manner and a punishment of up to 3 years imprisonment for the same. Challenging this legislation, a batch of writ petitions have been filed before the Supreme Court, the lead petition being that of politician and Islamic scholar A.R. Madani. The petitions challenge constitutional validity of the Act, calling it un-Islamic and violative of Articles 13, 14, 21 and 25 of the Constitution. Today, the division bench of Justice Sanjeev Khanna and Justice M.M. Sundaresh ordered the petition, Amir Rashdi Madani versus Union of India, to be treated as the lead petition. The matter will be heard in November this year. We will keep you updated with all the developments. Another important news coming from the Supreme Court regarding the plea filed by Telangana government before the Apex Court seeking directions to the Governor of Telangana, T. Soundararajan, to clear 10 bills passed by the Legislative Assembly which were awaiting her assent. Though the BRS government led by K. Chandrasekhar Rao had accused the governor of sitting on the bills, the governor Soundararajan had dismissed the allegations, stating that she was closely analyzing the bills. Today, the Supreme Court was informed that all the pending bills had been assented to by the governor. While disposing of the matter, the bench comprising CJI D.Y. Chandrachud and Justice P.S. Narasimha observed that bills should be returned as soon as possible to give effect to the first proviso of Article 200 of the Indian Constitution. This observation goes a long way as similar situations have been reported from different states. And now coming to another important development. In the criminal cases against Mumbai-based stand-up comedian Munawwar Farooqui for allegedly hurting the sentiments of people and allegedly insulting Union Home Minister and Bharatiya Janata Party leader Amit Shah, the Supreme Court today directed the transfer of all FIRs lodged against him in different states to Madhya Pradesh's Indore. Also, the bench of Justices B.R. Gawai and Sanjay Karol confirmed the ad interim bail granted to Farooqui in February 2021, making it absolute in terms of the earlier order. Munawwar Farooqui came under the public scanner in 2021 after his alleged remarks about Hindu deities and the Union Home Minister, which certain sections have claimed were derogatory and went viral. These statements were allegedly made as a part of his set during a stand-up comedy show in Madhya Pradesh's Indore. The principal bench of the National Green Tribunal today informed the Supreme Court that all suo motu cases arising from the Western Zone, which they had continued hearing despite specific instructions to the contrary, were all transferred. This development comes in less than 2 weeks after the principal bench was warned that contempt proceedings would be initiated against it for its defiance of the top court's order. The Supreme Court had expressed its disapproval over the principal bench of NGT allegedly continuing to hear cases from the Western Zone where they had taken suo motu cognizance in spite of the top court's restriction. And now coming to the last development for today, a positive news for the social media users regarding the case filed by stand-up comedian Kunal Kamra against the 2023 amendment of IT rules. As you already know that the amendment empowers the Ministry of Electronics and Information Technology to notify a fact-check unit that will identify fake, false or misleading online content in respect to any business of the central government. Kunal Kamra has approached the Bombay High Court challenging this amendment. According to Kamra's plea, through the new rule, the intermediaries, that is the social media platforms like Twitter, Instagram and Facebook, etc., are supposed to make reasonable efforts to cause users not to upload or share misleading information. Earlier, they only had to inform the users of their obligation to not upload or share patently false information. So Kunal Kamra says that he is a political satirist. He relies on social media platforms to share his content, and the impugned rules could potentially lead to his content being arbitrarily blocked, taken down, or his social media accounts being suspended. Last week, the ministry had filed an affidavit in response to this, citing an MIT research paper to assert that false news traveled 6 times faster than the truth, and that is why amendment to the IT rules was necessary. The ministry's affidavit is divided into several parts. On the whole, their point is that rules are in public interest and provide an evidence-based fact-checking system to deal with false or misleading information, which results in riots, mob lynching, and other heinous crimes, including those concerning the dignity of women and sexual abuse of children. The matter was listed for hearing today before the Bombay High Court bench of Justices Gautam Patel and Neela Gokhale. The bench observed that the new amendment prima facie lacks the necessary safeguards, and thus, on the face of it, the plea was maintainable. The court said that rule, however well-intentioned, did not have the necessary guardrails. Stay tuned for more updates on the matter. Thank you for watching. If you wish to know more details about the cases I mentioned here, please visit our website at www.livelaw.in. You can also read the articles by clicking on the links given in the description box. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.